So in the first part of the interview, we discussed alternative dispute resolution as a whole, just to understand the concept. But now we're going to focus on Singapore as an international dispute resolution center. So, Hannah, is Singapore turning into a center for alternative dispute resolution?
Yes, it is. Singapore stands today as one of the world's leading arbitration centers, and together with London is the most preferred center of arbitration, and in the region is the first in the Asia Pacific region. So it is the hub.
It clearly is,
Yeah.
yes. But why do you think it's gaining so much popularity?
Well, I think that's partly explained by the economic position of all the Asia Pacific region, together with Singapore's role in that context. So it is known to all of us that the region is one of the fastest growing regions in the world, and that is bringing a lot of investment and international companies here. So in this context, Singapore is really becoming the business and financial center. So companies are making Singapore their home for their businesses here. And where there are international companies, there are international transactions. And whether we like it or not, if they're behind every commercial decisions, there will be a dispute. So considering international companies for international transactions prefer arbitration as their dispute resolution mechanisms, then they are based here. Singapore, its government was very aware of that and set in place all this legal framework which has made Singapore arbitrations flourish in the state. Also, that means that the Singapore government has set out rules which benefit arbitration, but also we must bear in mind that the judiciary system in Singapore is open, is transparent, is based on the rule of law, and that is something that gives comfort to the international companies. And Singapore also benefits from the mistrust towards other jurisdictions which are surrounding the country. So a party would rather have their disputes settled in Singapore as opposed to Cambodia, Indonesia, or Vietnam.
Exactly. So, as companies come to Singapore for being such a dynamic and economic bubble, it also creates disputes, and the government has chosen to kind of encourage these alternative disputes. And this is why Singapore is such a leading hub that you have mentioned already.
Yeah, the government has been very fast in putting into place all the tools that are necessary for the international businesses to solve the disputes.
So for those international businesses and for Spanish companies, what are the advantages of choosing Singapore as a seat for arbitration?
Well, first of all, I think it's important to explain what the seat of an arbitration is, be it Singapore or any other country. So, because the seat of arbitration is not where the hearing will take place or where the arbitrators will gather to deliberate the decisions. The seat of the arbitration will determine the law that applies to all issues concerning the arbitration. So, the validity of the arbitration agreement, the nationality of the award, the final decision, and also other issues pertaining to the procedure or to the validity of the procedure of the arbitration. So, for instance, if an arbitration is seated in Singapore, the Singapore International Arbitration Act would apply to issues concerning all this, like the validity of the arbitration. And Singapore, it's a great choice as a seat of arbitration, precisely because they have the International Arbitration Act, which is based in the UN Commission of International Trade Rules, the model law, which is actually the same model law that has inspired the Spanish Arbitration Act and many other European arbitration acts. So it's a very good or valuable model law to follow. And also the judiciary system, the courts in Singapore has supported and protected the arbitration. So they have been rendering decisions which constantly protect the arbitration from parties to trying to deviate from what has been agreed and going to court, for instance. So yeah, and also in terms of enforcement of awards, the Singapore courts have enforced awards, and they do not hear appeals to awards just in very limited on very limited grounds. So that's
so that's great news. So we have we have understood why Singapore is so appealing for the mode of law as well. So we have talked about a general overview of the different alternative dispute mechanisms, but there are different figures in Singapore that Spanish or even Singaporeans may not be aware of. So is the Singaporean International Arbitration Centre, an important figure in arbitration?
Yes, the Singapore International Arbitration Centre, or SIAC, how it is known here. It was established, I think, in 1991, and it was established to promote, or with a view to promote, the dispute resolution settlements for international business. So the businesses here were demanding like a proper arbitration institution to resolve their disputes, and that's how it started. And any other arbitration institution, the SIAC provides supervision of arbitration procedures. They also facilitate a set of procedural rules, the SIAC rules, and they also help with other functions like appointment of arbitrators. So it's very good for the arbitration arena to have a strong institution which is established from the origin here in Singapore to make the arbitration stronger in the city, I would say.
Exactly. So Singapore already has a really strong and well-established figure in arbitration, as you have mentioned, but also in mediation, I guess. So can you explain what is the Singaporean International Mediation Centre?
Yeah. So the SIMC is the equivalent of the SIAC, but for the mediation. It's more recent. It got founded in 2014, and it's been working very well as international mediation is becoming more and more popular among international players. There are also, I think, they also have this blended formula with the SIAC, which is called arbitration. So parties could start arbitration before the SIAC, and the moment that the arbitration gets started, the arbitration gets stayed. So parties proceed to mediation before the SIMC, and if they cannot settle through mediation, then they will come back and resume the arbitration proceedings. So that's they are coming up with all these very creative, and actually they are working all these new ideas.
Exactly. Well, so we have mentioned a lot of ideas, and in case you want to know more about arbitration and mediation, you can check our first part of the interview with Hannah. But now just to introduce another figure more that we have in Singapore. Yeah. So what is exactly the Singapore International Commercial Court, and in which way it is different and it distinguishes between other courts and other arbitration seats?
So at the beginning of our interview, we were talking about the advantages and disadvantages of arbitration as opposed to court litigation. So in 2015, the Singapore government came up with this idea of why not having the benefits of both mechanisms blended in one institution. So they created the Singapore International Commercial Court, which belongs to the Singapore court system. It is actually a division of the Singapore High Court, but it's a court which specializes in international commercial disputes. So what makes it special is that it's not only that it deals with this type of disputes, but that it brings all the benefits from arbitration and like best practices in arbitration to court proceedings. So the judges that can be appointed in the SICC are from different jurisdictions: Canada, India, France, Australia, like very different jurisdictions. The rules of the procedure can be tailored or is flexible according to what the parties are looking for. Also, parties can agree for the proceedings to be confidential. That's something that really worries the international companies. And these are all like things that arbitration would have, but like the SICC also has the advantages of courts. So the fees are lower, they can render interim measures which are like immediately enforceable over parties, and all these things that we mentioned before. So it's an option that should not be disregarded by international companies, I would say.
Yes, I mean, it's the best of both worlds. Singapore has come up
Exactly.
with another figure that combines both, and it's really interesting to let the companies be aware of that. So for any Spanish company or any company, any international company listening, so why do you think they will choose Singapore as the jurisdiction, I mean, to solve the disputes, and not other jurisdictions that maybe not, I mean, they not be so familiar with? So for example, as you have mentioned, other Asia Pacific jurisdictions, or even the US jurisdiction, but even the Spanish jurisdiction. So why Singapore over the rest of them?
Yeah, so well, any European jurisdiction and any arbitration which takes place or is seated in Europe or in the US will work, I mean, most of them as good as Singapore is working.
Mm-hmm.
So the thing is that when a Spanish company is doing business here, their counterparty will probably not be Spanish.
Mm-hmm.
So that party will not be so happy to go to Spain or to Europe to resolve a dispute.
Mm-hmm.
They would rather go to a jurisdiction which is closer to their investment or closer to the reality of the project they are investing in.
Mm-hmm.
And in the region, it seems, from what all I've said, that Singapore is really the best choice. So
Exactly.
even though the options somewhere in Europe are still good,
Mm-hmm.
in the region, I think Singapore has the winning card.
Yes, I think by listening to your two interviews, we clearly get an idea where
Yeah.
Singapore really excels in this kind of dispute resolutions. So, and just to conclude the second part of the interview, Jana, so do you think there's a type of dispute or even a type of company that suits best the alternative dispute mechanism instead of the traditional one?
So I think it depends on the dispute, first of all, and on the type of contract and project. But I think if your business is international, if you're faced with an international counterparty, and I would rather go to arbitration than to court litigation or to SICC, because you are not so familiar with other local jurisdictions and with the law that governs the proceedings in these jurisdictions. And also, if you have if you are in a very specific sector such as maritime law or IP law, you can find institutions also in Singapore, I didn't mention them, but which are specialized in this type of dispute. So you have the Singapore Chamber of Maritime Arbitration, or the WIPO, Arbitration and Mediation Centre. So it seems to be in general more suitable to international disputes, but it's something to be considered thoroughly depending on the business.
Exactly. So I mean, we have listened to all the advantages, so the flexibility, the privacy, to be more specific, because the arbitrators can be not only judges, right, Jana? So
exactly. So the parties can agree on the entire procedure, and they can decide who they are appointing. So they can seek to someone who has a specialized knowledge in a specific field or industry which is important to understand their business or their dispute. So
yes. So I mean, when a dispute arises and the parties, I mean, they're anxious just to solve the conflict as best as possible. Having someone who kind of arbitrates the whole procedure, that understands perfectly the theme and the topic, it clearly gives
exactly
some kind of peace of mind, right?
And someone that will listen to you and will try to adjust the conduction of the proceedings to the needs of the parties.
Exactly. Well, so I mean, you have listened to Jana talk about all the different alternative dispute resolution mechanisms, and I mean, just listen to her ideas and just think about other ways like arbitration and mediation. So thank you very much, Jana, for being such a wonderful guest.
I hope I did help someone.
I'm sure you did.
Yeah.
Well, thank you very much for coming.
Thank you, Clara.
And thank you very much for listening. See you in the next week.